back in the day, when people created things, they didn't really care about intellectual property. Take, for example, those setting up WeChat official accounts, they'd use all sorts of images. But now you'll notice that many WeChat articles will say the images are from the internet. Contact us for removal if there's any infringement. They all do this trying to avoid infringement. But in fact, even after adding that, does it really avoid infringement? I don't know either. It doesn't seem reliable to me. But you might have heard about some magazine or other suing a bunch of WeChat content creators for copyright infringement. A lot of images online are actually copyrighted, not free to use, on intellectual property. Awareness will only get stronger. I remember buying pirated tapes. All the pirated stuff, I didn't think much of it. But now that awareness is gradually growing, it's hard to find pirated tapes anymore, right? But then again, nobody buys tapes anymore. Take Nice Cow Music, for example. Cool Music, they've all purchased music licenses, so they can stream it. Copyright awareness is on the rise. Let's take a look. When it comes to intellectual property, there are several types of IP strategies. One type is called a responsive IP strategy. Another is a proactive one. Both responsive and proactive strategies fall under the category of IP rights protection. Responsive strategies address IP rights after the fact. It's just the basic handling of IP, including IP mergers and acquisitions, monetization. All of these are passive responses. It's a passive response. And when it comes to dealing with rights, it's just reacting to the unexpected, responding to unexpected lawsuits. As for the proactive approach, it at least takes proactive steps, so it tries to avoid these issues. It actively identifies authorized partners, linking IP with the business. It builds awareness of IP rights, monitors risks. It also takes steps to avoid infringement. So it's still all about safeguarding rights. The reactive approach is the weakest, the lowest level. The proactive approach at the very least takes action. It aims to avoid harm to oneself and to avoid harming others. Moving on to the next level, we have the strategic and optimizing types. Both the strategic and optimizing types share a common characteristic. They generate revenue. That is, they use intellectual property to generate revenue. I license my IP to you, and you can use my product. You can sell it. Just share the profits with me after the sale. So the strategic approach means our IP should align with our overall business strategy, and its IP strategy and portfolio development should be aligned. We'll integrate IP into our portfolio management. We want our IP to generate revenue. Okay, we have a revenue target. We can make a good profit, right? Take at Qualcomm, for example. They make a business of selling intellectual property. They continuously analyze the situation and then protect their intellectual property. Okay, they actively protect it. And later on, it evolves to an even higher level. What does that look like? It's about a strategy driven by intellectual property, meaning intellectual property is our bread and butter. That's the idea. Intellectual property becomes a major source of revenue, and leveraging it for a competitive edge. Having a competitive edge based on intellectual property. The goal is to align IP with business objectives. So IP can directly generate significant revenue. It can propel our growth. Therefore, it's crucial for overall business operations. We will prioritize the protection of our IP. We even use specialized tools like radar to monitor. For any infringement of our IP, this is all about intellectual property. Now, let's briefly understand that the reactive type is the most basic form of rights protection. The proactive type actively engages in rights protection. And the strategic type leverages IP to generate revenue. When we get to the optimizing stage, IP becomes a strategic asset. It's a key way to generate revenue. Let's look at how different companies handle IP at various stages of their development. For instance, in the early startup phase, it's crucial to promptly secure patents for core products. It's also wise to seek distinctive trademarks. This helps set you apart from others. You don't want to end up benefiting someone else. As for copyright design, make sure to register all aspects of it. Registering copyrights essentially means, in the early startup phase, it's crucial to implement protective measures. This includes safeguarding trade secrets. As you move into the development stage, you should apply for more patents. You can license out unused patents. This will generate more profits, boost your brand awareness, aim to become a well-known trademark. This will increase your brand recognition. Later, we'll introduce the funnel model. More people will get to know us. Once you have a registered trademark, you'll have the chance to drive more traffic and potentially increase your revenue. Some companies, when they reach a mature stage, will have dedicated teams to handle patent applications and management, and also monitor and combat piracy. For instance, in my previous field, it was common since it's a pretty niche industry, many companies have likely received calls from some companies asking, are you using our software? You need to pay a fee. And then they get caught. It's almost always successful because anyone working in that field has to use certain industry software. That's for sure. So those companies, they specifically target all these infringements, how the patents are used, the licensing status, sell licenses, buy up these licenses. It's very common. His trademarks, monitor how his trademarks are used. Take the milk tea brand 这样 used in Hunan. You'll find in some smaller cities, they'll have one called something like 去on 去 C, or other knockoffs like T Cola, take KFC for example. You'll see copycats like KFD. You get the idea, right? Many of them will try to skirt the law, making it seem legit. But in fact, you might need to consider whether it's an infringement. This is about a business, in theory. We should prepare ahead of time for intellectual property protection, including patents, trademarks, copyrights, trade secrets, etc.